Is it wrong if the personal injury lawyer gets more than their client? So if their 30 or 40% of the case winds up with more actually going to the lawyer than the client nets with after they pay all the expenses and pay for the medical bills, is that wrong? My answer to that is usually yes. Why do I say usually? Sometimes what you're doing is not just advocating for the client, but you're advocating for some third party that has paid out substantial sums of money in that case. And that could be a disability provider. It could be, in certain circumstances for catastrophic cases, a health insurance company, and it could be a workers' compensation lien. So in those cases, sometimes an attorney is going to wind up with more, because ultimately what they're doing is they're not just advocating for you, they're advocating for the people who have advocated for you and paid for your bills thus far. But in other circumstances where it's a typical amount of money, right? Maybe you have a $30,000 or $50,000 settlement, and you've got, and half of it is in medical bills. And as hard as I try to negotiate, I can't get any further reductions than you owing half of that settlement. What we're going to do in almost every case is we're going to cut our fee so that we don't get more than the client. Because ultimately, something just sort of feels off about the attorney getting more for the case than their client. And I will tell you, many, many personal injury lawyers and personal injury law firms don't do this. So it's something worth asking up front. And we'll have an open discussion about it if you call my office.